Collision claims with Quadraant legal. Introduction. Collisions at sea are not just navigational accidents. They are complex legal events involving negligence, statutory rules, insurance, and international jurisdiction. In this video, we'll break down collision claims in maritime law, their causes, liability principles, and important case laws every law student must know. What is a collision claim? A collision claim arises when two or more vessels come into physical contact on navigable waters, leading to damage to ships, cargo, property, or even loss of life. Such incidents give rise to civil liability under maritime law and form one of the oldest and most litigated areas of Admiralty jurisdiction. Essential elements of a collision claim. For a valid collision claim, certain elements must be present. There must be at least two vessels. The collision must occur on navigable waters, there must be physical contact, and the incident must result in some form of damage or loss. Common causes of collisions. Most maritime collisions are caused by negligence rather than unavoidable accidents. Common causes include violation of the international regulations for preventing collisions at sea, known as COLREGs, failure to keep a proper lookout, excessive speed, poor communication, or mechanical failure. Ithay Oropesa, 1943, the court held that failure to maintain a proper lookout amounts to negligence. Role of COLREGs in collision claims. COLREGs play a central role in determining liability in collision claims. These rules prescribe how vessels must navigate to avoid collisions. Any violation of these rules is treated seriously by courts. In the Pennsylvania, 1873, principle, Pennsylvania rule, when a vessel violates a statutory rule, the burden shifts on that vessel to prove that the violation did not cause the collision. Types of collisions. Collisions are not limited to vessel-to-vessel contact. A vessel may collide with fixed objects such as bridges, jetties, or port installations, or floating objects like containers or wreckage. The legal principles governing liability remain largely the same. Determination of fault. The most critical aspect of a collision claim is determining fault. Courts examine navigation conduct, compliance with COLREGs, speed, lookout, and decision-making. Sole fault. One vessel entirely negligent. Contributory fault. Both vessels negligent. Inevitable accident. No negligence. Collision unavoidable. Principle of apportionment of liability. When both vessels are found negligent, courts apply the principle of apportionment. Damages are divided between the vessels in proportion to their degree of fault. Classic case. The Bywell Castle, 1879. Even if one vessel committed the final error, liability is shared if both vessels were negligent earlier. Losses covered under collision claims. Collision claims may involve multiple categories of losses, including physical damage to vessels, cargo claims, environmental pollution, and compensation for injury or loss of life. This makes collision disputes legally and financially complex. Role of marine insurance. Marine insurance is vital in collision claims. Hull and machinery insurance covers damage to the vessel itself, while protection and indemnity clubs cover third-party liabilities such as cargo damage, pollution claims, and crew injuries. Collision liabilities are predominantly indemnified through P&I club insurance. Resolution of collision disputes. Collision disputes may be resolved through Admiralty courts, arbitration where contractual clauses exist, or through negotiated settlements. In MV Elizabeth v. Harwin Investment, 1993, recognized the wide Admiralty jurisdiction of Indian courts in maritime claims, including collisions. Why collision claims are important. Collision claims are crucial in maritime law due to the high financial stakes, international nature of shipping, and strict compliance required with navigational and safety regulations. Conclusion. In conclusion, collision claims form a core area of maritime law, governed by principles of negligence, statutory compliance, and apportionment of liability. A sound understanding of collision claims is essential for law students, maritime professionals, and insurers alike. If you found this video useful, like, share, and subscribe for more maritime law content. Drop your questions in the comments and we'll see you in the next video. The information provided here is for educational purpose only and does not constitute as a legal advice or solicitation. Welcome aboard. Like, share and subscribe.